In the final 3 lectures, we are going to cover the final substantive topic area, which, as set out on the slide, covers breach, liability and remedies. Remember, a person who acts as a trustee is in a powerful and privileged position, not least because the trust property is vested legally in his or her name. We know that the role of a trustee is a fiduciary role, and as such a trustee must always act in the best interest of the beneficiaries. And we also know that the trustee's powers and duties are governed by both statutory provisions and common law rules. So the questions that we are going to be looking at in these lectures and in your final workshop are: what constitutes a breach of trust? What happens when a breach occurs? Who is liable for the breach and to what extent? And what remedies are available to the beneficiaries? So, first things first, what constitutes a breach of trust? Well, as set out on the slide for you there, a breach of trust occurs if a trustee does any act which he ought not to do, or fails to do an act which he ought to do with regard to the administration of the trust, or with regard to the beneficial interests arising under the trust. Now, this may seem fairly obvious, but lay people would often consider a breach to be concerned only with positive acts, and often they are. But a breach of trust can equally involve the failure of a trustee to act when there is a positive duty to do so. And what we're talking about there is an omission to act. And so a breach of trust may concern either a positive act or the omission to act. Here we can identify 3 broad categories of breach. The first, as set out on the slide, breaches of fiduciary duty by which a trustee gains an unauthorised profit, we've already considered in some detail. So some examples of this type of breach can be seen in the cases of Bray and Ford and Boardman and Phipps. Remember, the nature of a fiduciary role is that the fiduciary is expected to act impartially and in the best interest of his or her principal. So this means that they must have no personal interest in the way that the duty is performed, and a trustee must be motivated to benefit the trust and not himself. So in Bray and Ford, Lord Herschel, in recognising the no conflict and no profit duties, concluded that they existed because of the danger of the fiduciary being swayed by personal interests rather than duty, and thus prejudicing those whom he or she were bound to protect. So in other words, the strict duties operate to insulate the fiduciary from distracting influences and to ensure that the fiduciary resists the temptation to serve himself or herself rather than the principal. This is essentially a control mechanism aimed at protecting the principal against the abuse of the fiduciary's position. This very strict approach was applied in Boardman and Phipps, which established the principle that fiduciaries must account for any profit obtained from information and opportunities gained in their fiduciary role. Note here that this very strict approach has been criticised in that the principles were established in an era where we did not have such a strict control of fiduciaries acting in their professional capacity. Professions such as solicitors, for example, are now governed by the relevant professional bodies, and it can be argued, therefore, that such a strict approach is no longer necessary, and in fact it can stifle entrepreneurial spirit, which could act in favour of the beneficiaries. The case of Boardman and Phipps could be discussed in order to support this argument. So, moving on to the second broad category, breaches by the trustee of his duty to act with care and skill in the administration of the trust. These are the more general types of breach. We've already been considered in the lectures covering administration of the trust, but there is some crossover here, and so it'd be useful to recap on the key principles. So, trustees are required to perform their administrative responsibilities diligently and are subject to a duty to comply with the standard of skill and care expected of all trustees. There are two distinct tests of the duty of care, one at common law and the other statutory. So, dealing with the common law test, a trustee must exercise the same standard of diligence and care as an ordinary prudent person would exercise in the management of his or her own affairs. Spate and Gaunt is the authority for this. Or alternatively, the higher standard that was applied in Re Whiteley, that is, the standard that an ordinary prudent person would adopt when acting for the benefit of other people for whom he or she felt morally bound to provide. Remember, this standard only applies to amateur or non-professional trustees. A higher standard of care is expected of a paid professional, namely the standard that such a professional would be expected to exhibit, as was held in Re Waterman's Wills Trusts, 1952. So, moving on to the statutory duty of care, this is now covered by the Trustee Act 2000, which creates a statutory duty of care that now applies when trustees carry out most administrative powers and fulfil most duties. There are some exceptions to this, such as the dispositive powers of trust property to beneficiaries, of maintenance and advancement. These are still governed by the common law duty of care. As discussed in previous lectures, Schedule 1 of the Trustee Act 2000 sets out the statutory duty of care. So, the final third category, broad category, concerns the misapplication of trust property, for example, where the trustee in breach pays money to a third party. So these involve dealing with the trust property in some wrongful way, and it's in these situations that the beneficiaries may wish to hold a third party liable. The liability of third parties, also referred to as strangers to the trust, will be covered in detail in the final lecture. So I've just set out on this slide, again, some examples of breaches of trust. So now we've identified what constitutes a breach of trust, clearly an important question is which of the trustees is guilty of a breach of trust. So we're now going to move on to look at who is liable and the extent of the liability. The first principle that we're going to consider in regards to trustee liability is the link between the breach and the loss. There must be a breach of trust, a loss to the trust, and a causal link between the two. So, where there's been no loss to the trust, no liability can arise in respect of a breach. Also, If the loss would have occurred in any event, as was argued by the defendants in Target Holdings and Redfearns, the trustees would still not be liable. We'll look at the key case of Target Holdings and Redfearns later in the lecture. It's important to remember the wide scope of liability in terms of a breach of trust. There are no degrees of breach as such. Liability exists independently of fraud. It can attach to a trustee who has acted honestly and in the beneficiary's best interests, but perhaps, say, without skill and care, or with a lack of knowledge or incompetence. Just as it can attach to one who has acted fraudulently and is in his own interests. The reason for this is that it's the protection of the beneficiaries and not the nature of the wrongdoing that is the key driver. The standard of care expected is objective, that of the reasonable person. So, lacking the relevant knowledge or skills is no defence. If the trustee is in fact incompetent, when measured against the reasonable person, they were still held to be liable. The court, however, does now have a discretion to grant relief from liability. This is framed in the defences to liability, which we'll consider later in the lecture. And as such, they can or may take such matters into account when exercising this discretion. So, the trustee's liability is to make good to the beneficiaries any resultant loss to the trust estate, or to account for any profit made. This may be by the recovery of the trust property itself, so a proprietary remedy in the property itself, or by making the trustee personally liable for any loss to the trust fund or for any unauthorised profit that's been made. So that is a personal remedy. And so the beneficiaries may seek to bring claims either to recover the original trust property or its substitute, and we'll look at this in the later lectures, or to recover its equivalent monetary worth from the trustees, and in certain circumstances from third parties. This ability to recover via personal or proprietary remedies takes us full circle back to our discussions in the introductory lectures and workshop on the nature of the beneficial interest under a trust. Remember, we discussed whether the nature of the beneficiary's interests is purely personal or whether they have rights in the property itself. So the ability to recover by both personal and proprietary remedies demonstrates that the beneficiaries do have both personal and proprietary rights, a hybrid right. And this obviously is of benefit when looking at breach, liability and remedies, because it gives the beneficiaries a number of options when looking at how to recover for the loss which was the result of a breach. The responsibility of trustees in breach to make good the loss to the trust fund or to account for any unauthorised profit equates to restitution. And restitution in this context means the restoration of the actual property itself or its equivalent cash value. Now that covers the extent of liability. We're now going to move on and look at who is liable. Remember, There will usually be more than one trustee. In fact, it is not advisable to have just one trustee. To appoint only one trustee puts them in a very powerful position. It's advised that several trustees act together as a check and balance, and this makes it far less likely that a breach would occur. Also, it's not possible to appoint one trustee in certain situations, such as where the trust property includes land. But where there has been a breach of trust and a resultant loss, trustees are said to be jointly and severally liable, regardless as to who is at fault. This means that the beneficiaries can choose to sue one or all of the trustees. This makes sense because trustees in general are expected to act jointly, and so the principles regarding liability should not encourage passive trusteeship. There is no such thing as a sleeping trustee. So, can you think why and in what circumstances it would be beneficial to the beneficiaries to apply the joint and several liability rule? Well, in circumstances where the trustee has absconded and his whereabouts are unknown, or where a trustee has become bankrupt, it would obviously not be beneficial to sue that particular trustee. So this again shows the wide liability in terms of remedies, but the protection of the beneficiaries again is the key driver and not the nature of the wrongdoing of the trustee. So, as stated, in general, trustees are expected to act jointly, and as such, the rules in relation to liability reflect this in holding that trustees are jointly and severally liable. The trust property is required to be vested in trustees jointly, and all trustees have a duty to receive any trust income. There are some examples of exceptions to this, such as if the trust instrument directs otherwise, but these are exceptional circumstances. Standing idly by or turning a blind eye while a co-trustee commits a breach constitutes a breach of trust in itself. Stiles and Guy goes further than this and established the principle that it is the duty of a trustee to watch over and, if necessary, correct the conduct of each other. We've looked at the position from the point of view of the beneficiary who is looking to recover for a breach. Now let's step into the shoes of the trustees. A trustee is liable for his own breaches and not for those of his co-trustees, and the authority for this, as set out on the slide, is Townley and Sherborne. Now, at first glance, this appears to contradict the joint and several liability rule, but this is not the case, as we'll see on the next slide. To explain the no vicarious liability rule in more detail, we know that a beneficiary can proceed against any trustee in relation to the loss. So this is applying the joint and several liability rule, which favours the beneficiary. However, no individual trustee will be liable for any default, which is the default individually of another trustee. So, trustees are not vicariously liable for each other's breach, but of course they are required to act jointly. So any trustee who leaves the administration of the trust to others does so at their own peril. There is no such thing as a sleeping trustee. There's a duty to act. Likewise, no trustee should stand by while a breach of trust is being committed by his fellow trustees, or having become aware of the breach of trust, take no steps to recover the loss. But any trustee who's been required to compensate a beneficiary may subsequently recover any compensation from the trustee whose actions were actually responsible for the breach. So just to clarify this point, because some students do find this confusing, the beneficiary may sue joint and severally any or all of the trustees, and this obviously works in favour of the beneficiaries. However, the trustees in a separate action may seek recovery of that compensation from the trustee who was actually responsible for the breach. A trustee is not liable for breaches that were committed by predecessors. However, on appointment, he does have a duty to examine the trust books and documents and to ensure that the trust property is vested in him. He has a duty to take action against the former trustee if he discovers that a breach of trust has taken place, unless, that is, proceedings would not benefit the trust. For example, if the former trustee is bankrupt. A trustee cannot retire to escape liability. Even after retirement, he retains liable for breaches committed while he was in office, with certain exceptions that are set out on the slide. If he dies, his estate remains liable after his death. I stated earlier that compensation in terms of breach of trust equates to restitution. So the beneficiary must be put in the same position as he would have been had the breach not been committed. But also, if a breach has been committed and the loss is not caused by that breach, again, there'll be no liability. And the leading case on this is Target Holdings and Redfern. So, in Target Holdings, the House of Lords considered the principles to be applied in determining the issues of causation and remoteness in cases of breach of trust. It was held that there had to be a causal link between the breach and the loss. Now, this softened the strict liability approach which had been applied in older cases. In this case, Redferns acted as solicitors for Target Holdings. They were acting in relation to a mortgage for the purchase of land, and although they had committed a breach because they paid over money to the mortgagor before the mortgage had been completed, the breach was not the cause of the loss suffered by Target Holdings. The loss was caused as a result of a fraudulent valuation of the land over which they took out the mortgage. So the House of Lords held that Target Holdings could not be awarded compensation from Redferns for breach of trust, and the principle established that the loss suffered must be as a direct result of the breach. So, we know that liability as between trustees is joint and several. The beneficiaries may choose to sue one or all or any of the trustees in order to recover their loss. But as between the trustees, until the introduction of the Civil Liabilities Contribution Act in 1978, which is set out on the next slide, trustees were regarded as being equally liable. And so a trustee who had been compelled to pay more than his or her fair share of the loss could, in a separate action, enforce a contribution from the others. And in enforcing equal contributions, the courts disregarded any different degrees of involvement in the breach of trust. So a passive trustee was as liable as an active one. This changed with the introduction of the Act. The relevant provisions of the Act are set out here on the slide, so I'll just give you a moment to read that. So these provisions include damages arising from a breach of trust. The Act now gives the courts a discretion to depart from the rule of equal distribution, so they can take into consideration degrees of fault, and this may amount to a total indemnity. So following the 1978 Act, as between the trustees, the court now has a discretion as to their share of liability. So they can take into consideration how active a trustee has been in the breach. However, before the Act, there were exceptions to this principle of equal contribution, and these exceptions were unaffected by the new legislation. So the three key exceptions are set out there on the slide. First, where the trustee is fraudulent and has exclusively benefited from the breach, the other trustees can claim an indemnity. And just to clarify what we mean by indemnity, it's a sum paid by way of compensation. So a fraudulent trustee is solely liable and can claim no contribution from honest trustees. The second exception to equal liability, which still holds good, is the rule that where a trustee is also acting as a solicitor, not in all situations, it must be shown that the other trustees followed the advice of the solicitor trustee who exercises a controlling influence over them. So being a solicitor and a trustee does not automatically indemnify the other trustees. For example, in the case of Heald and Gould, G-O-U-L-D, 1978, it was held that other active participants in the breach were still liable. The third example is under the rule in Chillingworth and Chambers, where one of the trustees is also a beneficiary of the trust and intended to profit by the breach. The trustee beneficiary must indemnify the other trustees to the full extent of his beneficial interest. So not just the extent to which he personally benefited, but the full extent of his beneficial interest. Once that interest is exhausted, any further liability will then be shared out equally. Now let's look at ways in which the trustee may exclude liability, either wholly or in part, which is framed as defences. The key way is through an exclusion clause, which we're going to cover in the next few slides. So I'll move on to the second. So where a trustee can be protected if a beneficiary knowingly consents to the breach of trust. In this case, the beneficiary cannot complain of the trustee's conduct in committing the breach and cannot recover his losses resulting from the breach. In a case which followed this principle was Fletcher and Collis. By virtue of Section 62 of the Trustee Act 1925, where a trustee who breaches a trust at the instigation or request or with the written consent of a beneficiary, the court has a discretion to impound all or part of the beneficiary's interest in the trust estate, and this is then used to indemnify the trustee. Where the beneficiary's interest is impounded, the effect is that compensation for the breach of trust will be provided for out of the beneficiary's share of the trust fund, rather than paid for by the trustee. This doesn't exclude the trustee from liability, it only compensates up to the value of the beneficial interest. Section 61 of the Trustee Act 1925 gives the court a discretion to relieve a trustee wholly or partly from liability where he or she has acted honestly and reasonably and ought fairly to be excluded for the breach of trust and for omitting to obtain the directions of the court. Now, this discretion has been criticised and it still remains unclear as to when the judicial discretion might be exercised, and in fact in practice it is rarely used. Exclusion clauses are much more heavily relied upon. In terms of the statute of limitations, in general, the effect of this provision is that if the beneficiaries are seeking a proprietary remedy, that is to recover trust property in the hands of trustees, their claim is not subject to any statutory time limit. Whereas if they are seeking any other action against the trustee for breach of trust, it will be subject to a 6-year time limit unless it concerns fraud. So most personal actions against trustees will be subject to the 6-year limit. So we're now going to look for the next few slides at the use of exclusion clauses. I would like to point out though that the number of slides and the detail does not reflect the amount of knowledge that you need to know in this area. In the past, the debate around the use of exclusion clauses, which is a hot potato in terms of equity and trusts, has been included on the exam paper as an essay question, and so required a large amount of evaluation and critique. That will not be the case this year. So yes, you do need to be aware of exclusion clauses, and you need to look at them in terms of a problem question, and you could give critique, but not in the amount of detail that is included in the rest of these lecture slides. So I'm going to basically talk through the key points here. So the Trustee Act 2000, Schedule 1, Paragraph 7, provides that the statutory duty of care will not apply if or insofar as it appears from the trust instrument that the duty is not meant to apply. So in layman's terms, it means that an express provision can be included in the trust deed which purports to limit the liability of the trustees. And the key question before the case of Armitage and Nurse, which is on the next slide, was, does the exclusion clause, or would rather an exclusion clause, be sufficient to exclude liability under the statutory duty of care? The trust instrument may contain a clause excluding liability for certain types of breach, and if it does, the beneficiaries will be unable to bring an action if the clause is held to be valid, and the wording of the clause relieves the trustees from the type of breach in question. Now, The use of exclusion clauses has been heavily criticised. Hudson particularly is critical of the use of exclusion clauses, and they are most commonly used where the trustees are acting in a professional capacity. Now, the counter-argument to this is that the fact that the liability for breach of trust is so wide, as we've seen, means that the use of an exclusion clause is a valid mechanism to provide some limitation on the unrestricted nature of the liability for breach of trust. And the key case in which the validity of these clauses was considered was in the case of Armitage and Nurse. Set out in the trust instrument, in the case of Armitage and Nurse, was the clause that no trustee shall be liable for any loss or damage which may happen to Paul's fund or any part thereof or the income thereof at any time or from any cause whatsoever, unless such loss or damage shall be caused by his own actual fraud. So you can see the extent of this exclusion was very wide. In fact, the trustees would only be liable for dishonest breaches, and the clause would protect them against actions of negligence, even up to gross negligence. In the key case of Armitage and Nurse, the Court of Appeal rejected the argument that a clause that excludes liability for gross negligence is void because it's repugnant to the very nature of the trust. However, critique of this position, if we think back to the three broad categories of types of breach, the second and more general type of breach were breaches by the trustee of his duty to act with care and skill in the administration of the trust, and that we discussed that these principles were on both a common law footing and a statutory footing under the Trustee Act 2000. So, as Hudson argues, the irreducible core or the nature of the trustee's role is to act competently and in good practice. And so, by allowing exclusion clauses which exclude liability up until including gross negligence is contradictory to these principles. But the law as it stands establishes that if the clause is clear and includes the type of liability, they will be enforceable. Since the decision in Armitage and Nurse, it's become clear that the court will give effect to clauses which unambiguously relieve a trustee from liability for gross or any other level of negligence. Therefore, many of these cases have involved issues of construction and whether there's been any ambiguity in the drafting of the clause. One of the key objections to the operation of exclusion clauses is that they can be relied upon by trustees even if the trustee was the very person who drafted the provision, meaning that a trustee can ensure freedom from liability. It is important to note, though, that in the case of Armitage and Nurse, it allowed exclusion of liability with the exception of fraud, and fraud has been equated to dishonesty. So, Millis has also stated that exemption clauses would have to be allowed, otherwise individuals may refuse to act as trustees, and this was one of the justifications given in the leading judgment. As Hudson points out, however, This is effectively a circular argument, because if someone agrees to act as a trustee, then it must be taken surely that they accept the general obligations of good conscience and good management required of a trustee. And so to allow extensive exclusion clauses subverts the necessary stringency of the law dealing with the office of trustee. In subsequent cases, such as Bog and Raper, the courts attempted to mitigate the wide exclusion of liability by construing exclusion clauses very restrictively, so that anything that is not clearly within it should be treated as falling outside it. But this didn't really make any difference, because people drafting the clauses just became much more efficient in making it absolutely clear as to every restriction that would apply. Following the decision in Armitage and Nurse, there was much debate and criticism as to the extent of the use of exclusion clauses, and in response to this, the Law Committee published a consultation paper in April 1999, Trustee Exemption Clauses. So there have been a number of official reports regards the validity of exclusion clauses, as well as much academic debate as to the justification. And in the committee report 1999, it was recommended that the use of exclusion clauses should be distinguished between professional trustees and lay trustees. This recommendation for a distinction between the use of exclusion clauses between professional and lay trustee was also put forward in the Law Commission's consultation paper, Trustee Exemption Clauses, which was published in 2003. The recommendations that came out of the consultation were that professional trustees, and that is whether they are paid or not, should not be able to exclude liability for negligence, although most would accept that lay trustees who acted gratuitously should be able to exclude liability. Following on from the consultation paper, the Law Commission published its recommendations in the report Trustee Exemption Clauses in 2006. It recommended that a non-statutory rule of practice be adopted. Now, this rejected the recommendations from the consultation paper of 2003, which called for statutory regulation of exclusion clauses. So the report recommends that the trust industry adopt a non-statutory rule of practice, and that this should be enforced by the regulatory and professional bodies which govern and influence trustees and the drafters of trusts. So we now have a rule of practice, and this governs disclosure and explanation of clauses in trust instruments which have the effect of limiting or excluding liability for negligence. Paid trustees must take reasonable steps to ensure that settlers understand the meaning and effect of such clauses before including them in trust instruments, and drafters of trusts should also be subject to the rule. There was criticism that the recommendations did not follow those of the consultation paper in placing this on a statutory footing, but after the extensive consultation process, the Law Commission felt that the consultation process proposed distinction between professionals and lay trustees would be difficult to apply in practice and liable to cause unfairness, and especially in relation to professionals acting pro bono. And also they said it would have potentially an adverse impact if it was a statutory regulation, including the reluctance to accept trusteeship. I've summarised here the reasons for adopting a rule of practice as opposed to statutory regulation, the sort of pros and cons here. So in relation to statutory regulation, it was argued that it could lead to defensive trusteeship, involving having to seek independent legal advice. It would create problems of evidence and would require strict test of disclosure. And it would cause a lack of certainty. The potential for exemption clauses being held to be invalid would lead to lack of certainty. In terms of a rule of practice, it was argued that it created more flexibility. The regulatory bodies, of the relevant provisions are in a different position from the courts. It was argued that they would be concerned to promote compliance with the spirit of the rule and the wider aims of regulation. And it would be unlikely to be overly concerned with unintentional, minor or technical breaches, provided that the trustee had acted with reasonable care and in good faith. So, we've now covered what constitutes a breach, scope of liability, who is liable and some defences to liability, and we'll be moving on now to remedies for breach of trust, and these fall into two categories: personal actions against the trustee, such as damages for a breach of trust, liability to account for profits made, or other general equitable remedies, and proprietary actions which are in the property itself. We've discussed the fact that a beneficiary's rights include both personal rights and proprietary rights, rights in the property itself. And because they have proprietary rights, they can enforce these against any person that comes into possession of trust property other than the BFP, the bona fide purchaser for value without notice. So, suppose that a trustee holds on trust for a beneficiary and misappropriates trust property, such as a painting belonging to the trust. The beneficiary can assert his proprietary interest against the trustee. He can reclaim the trust property, the painting, because the painting remains trust property. Now suppose that the trustee transfers the painting to a third party. A beneficiary can bring a proprietary claim against the third party to recover the painting unless the third party was a bona fide purchaser for value without notice. So they paid good value without notice or knowledge that it was part of a trust fund. So if the recipient is a bona fide purchaser, the beneficiary's equitable interest exists in the sale proceeds held by the trustee. So in both these cases, the trustee was in breach of trust and the beneficiary has a personal claim against the trustee for compensation. However, there may be good reasons why the beneficiary wishes to pursue a proprietary claim instead, in that they might wish to recover the actual trust property, in this case, the painting. As stated before, the hybrid nature of the rights of a beneficiary have many benefits, and the fact that they can make a claim in the property, a proprietary claim, can be advantageous, such as in situations as where the trustee has been declared bankrupt. There's no point suing a bankrupt trustee. Whereas, unlike a personal claim, a proprietary claim under a trust has priority over other creditors on bankruptcy. So the claim attaches to the property and as long as the property is ascertainable in either its original form or substituted form, that property is ring-fenced and doesn't become part of the assets of the bankrupt trustee and can be claimed by the beneficiaries. A proprietary claim can only be brought if the claimant can identify the property or its substitute, and in order to do so, this may require a tracing order, and that is the area that we're going to be looking at in detail in the next slides. Hello again. So we're now moving on to the second lecture, which covers the topic area of breach liability and remedies. We have established what constitutes a breach of trust. We've established who is liable and to what extent. And in this lecture, we will be concentrating on a remedy which demonstrates the flexibility and benefits of the beneficiary's proprietary rights in the trust property. So remember, Lord Brown Wilkinson, in his leading judgment in the Westdeutscher case, stated that once a trust is established, the beneficiaries have a proprietary right in the trust property. So where a breach of trust has occurred and there's a loss to the trust fund or the beneficial interest, and there's a causal link between the breach and the loss, this proprietary right gives the beneficiaries the option in certain circumstances of recovering the actual trust property in the hands of the trustee in breach, or from the hands of a third party who's come into possession of the trust property. Third parties other than bona fide purchasers for value without notice. The process by which beneficiaries can recover the trust property or its substitute is the process of equitable tracing. Tracing is available where a personal remedy, that is to sue the trustee or a third party, will not suffice. It's available both at common law and in equity, but there are key advantages to equitable tracing over common law tracing, and we'll look at these later in the lecture. Tracing is not a remedy in itself. It's a process by which property is identified in some traceable form, over which a claim may then be made and which may lead to a remedy. Now, in the textbooks, tracing is often included under the heading of remedies, so don't be confused by this. The three requirements established in order to apply for a tracing order were set out in the key case of Re Diplock, 1948. The first requirement is that there must be an initial fiduciary relationship. And in terms of a trust, we know that a trustee is an example of a fiduciary role. So the claimant has an equitable proprietary interest in the trust property. The second requirement is that the property must be traceable in some ascertainable form. This doesn't have to be the original trust property. It may be, and quite often is, a substitute, but there must be property in an ascertainable form that can be traced back to the initial trust property. If the trust property has been dissipated, then equitable tracing cannot be used. The final requirement is that there must be no inequitable results. So we'll be looking at the rules in relation to third parties and innocent volunteers, because remember, in our introductory lectures and workshops we established that equitable jurisdiction is discretionary. So in enforcing remedies, the courts will take into account any effect that a remedy has on a third party. So where a personal claim is inadequate, the claimant may be awarded a tracing order. Tracing is particularly beneficial where trustees who have misused trust property are bankrupt or insolvent. as the beneficiaries have a proprietary right in the trust property, and that proprietary right takes priority over other creditors, over personal creditors. Now, a number of complicated scenarios can result from the misuse of trust property. As pointed out in Todd and Wilson, stolen property or property obtained in breach of trust is often hot property and can change hands several times through various parties to be used to purchase other property, and can eventually end up in the hands of someone entirely unconnected with the original wrongdoing, who has no knowledge of that wrongdoing. This person is referred to as an innocent volunteer. So it's highly unlikely that trust property will simply be sat waiting, for example, in a bank account, waiting to be recovered. So we look at the basic rules in relation to a number of scenarios, and then our work in the final workshops will enable us to put these rules into practice. So as we've established, Reed Diblock concluded that a fiduciary relationship was a prerequisite to equitable tracing. So there must be an initial fiduciary relationship, and this was recently confirmed in the case of Box and Barclays Bank, 1998. Now, of course, there are other relationships in which one party owes a fiduciary relationship to another, and the rules in relation to equitable tracing apply to all of these. So some examples would be banks towards their clients, employers to employees, partners, solicitors to their clients, directors to the shareholders, and so on. So to reinforce your understanding of this requirement, we're going to look at 3 scenarios over the next slides, and I'll give you the opportunity to read the first one. So please read the example on this slide. So in this scenario, we have Ted and Tom, who are the trustees, and Grenville, who's a beneficiary. And if you consider the 3 different examples, we have property that's ascertainable. In the first, it's a house. In the second, it's the car. And in the third, it's the shares. So Grenville is a beneficiary and he wishes to recover the trust property. So because he's a beneficiary, he can use equitable tracing to identify the original trust property or its substitute and to recover it. The first one's straightforward. The house is a substitute for the £130,000. So he can identify the house as trust property and recover it. In the second example, again, Grenville is a beneficiary and he can use equitable tracing to identify the car as trust property. He can bring a proprietary claim against Sandra. Remember, Sandra's a third party. Beneficiaries can bring proprietary claims against any person who receives the trust property except a bona fide purchaser. So the action will not necessarily be brought against the person responsible for the original wrongdoing, i.e. the trustee, but against a third party, as is the case here. The third party who has come into possession of the property, which is Sandra in this case. The remedy is proprietary in the sense that it goes with the property, it follows the property. And the liability of the third party depends on their possession of that property. So Sandra is in possession of the car, which is a substitute for the original £20,000 obtained in breach. She was given the car by Tom, so she isn't a bona fide purchaser because she didn't give good value for it. And so, although she's an innocent volunteer, that's the term that will be used, Sandra, if Sandra had no knowledge of the fact that the car was bought from monies obtained in breach, she would be an innocent volunteer. However, beneficiaries can trace into the hands of an innocent volunteer. And that's the same in the third example given. So Tom made an unauthorised profit of £50,000. We know that that is a breach of trust. So the profit of £50,000 would be held on constructive trust for Grenville, and it was used to buy shares, and they were transferred to his father, Bill. So in this case, again, it doesn't state that Bill gave any value for the shares, they were simply transferred to him, in which case Bill may be an innocent volunteer, he has no knowledge of the fact that the shares were bought from money obtained in breach, but Grenville can still trace the property into the hands of the third party. Again, I'll just give you some time to read the examples on this slide. So remember we said that equitable tracing can be used where there's any fiduciary relationship. So the first example, we're looking at the director, and the company owns legal title to its bank account and other assets. However, directors owe the company, which is represented by the shareholders, fiduciary duties. So the company can use equitable tracing to identify its property in the yacht. And this is an example where a personal remedy would not suffice because the trustee in breach has been declared bankrupt. In the second example, Jack is a personal representative. Personal representatives owe the beneficiaries fiduciary duties, so they can use equitable tracing to identify their property in Bobby's hands. So again, Bobby may be an innocent volunteer. He may not have any knowledge that the monies were obtained in breach, but unless he's a BFP, a bona fide purchaser, and there's nothing that indicates that he gave good value for the monies, then it would mean that the money can be traced into the hands of Bobby and recovered. So we've seen from the previous examples that there's a requirement that there is a proprietary right in the property, so there's a fiduciary relationship, and the second requirement is that the property must be ascertainable in a traceable form. So in all of these cases, the examples that are given on this slide, the beneficiaries wouldn't be able to trace because the money's been dissipated. It no longer exists in either its original or a substituted form. Remember though, although tracing is not possible, they still have a personal claim against the trustee for breach of trust. So a proprietary claim involves the claimant being able to identify his property either in the original form or a substitute in the hands of the defendant. It's said to be following the property. It's a right in the property itself. So the next question to consider is which set of tracing rules apply. We stated earlier that property obtained in breach is often hot property, it passes through several hands and changes form. This scenario here, tracing into unmixed funds, is the most straightforward set of circumstances, and as such it's obviously the least likely to occur in practice. The leading case which set out the rules in relation to tracing into unmixed funds is Re Hallett's Estate, 1880, which is set out on a slide further on. So there's no difficulty whatsoever in tracing into trust property where it's been preserved as, say, for example, a separate fund in a bank account, or where it's been replaced by something else, a straightforward substitution. These are situations where the property is not being mixed with other funds, other monies, for example, or other assets. And the simple rule is that beneficiaries in these situations can trace to the exclusion of other creditors because they have a right in the property itself. The only question you may have to consider is what remedy to claim. So you've traced the property, but remember, tracing is a process which may lead to a remedy. So the question would be, should the claimant claim either ownership of the asset itself or place a charge over the property? So once equitable tracing has been used to trace the property into a substitute form, then property purchased with unmixed funds, the beneficiary can either claim the property itself or they can assert an equitable charge, also referred to as a lien, L-I-E-N, but an equitable charge will suffice over the property. So they may wish to assert an equitable charge over the property as security to support a personal claim, and the authority for this, as we stated, is Re Hallett's Estates. So what do we mean by an equitable charge then? Well, an equitable charge means that if the trustee does not pay the sum due, so remember, you have a right to sue the trustee, a personal claim to make good any loss to the trust fund. So if you place an equitable charge over property obtained in breach, and then the trustee does not pay the sum due, the beneficiaries can insist on a sale of the charged property to recover the sum out of the proceeds. A charge is an equitable remedy. The benefit of this is that equity can trace into mixed funds, and this is one of the key advantages of equitable tracing over common law tracing, because in general, common law tracing does not allow tracing into mixed funds. So equity works by the declaration of a charge on the property, and this is not defeated by mixing. The next set of circumstances that we're going to look at becomes more complicated, tracing into mixed funds. So what we're looking at here is perhaps where a trustee has obtained money in breach of trust and paid it into a bank account that already contains funds from another source, usually his own personal funds. So we now have a mixture between funds obtained in breach from the trust and the trustee's own funds. So if this is the case and no withdrawals are made after the mixing, it's quite straightforward because the beneficiary can simply claim the proportionate part of the mixed fund which derived from the trust, and that is again in priority to the trustee's other creditors because it's a proprietary right in the trust property, and the authority again for this rule is Re Hallett's Estates. So we've now looked at situations in which you can trace into unmixed funds. We've looked at situations where the funds are mixed but there's no withdrawals from that mixed fund. And now we're looking at a situation where trust money has been mixed with the trustee's own money and then used to buy an asset. In this situation, the leading case is now Foskett and McGowan, and the beneficiaries may claim a proportionate share of the asset, or they may place an equitable charge over the property purchased to the extent or the proportion that trust money was used to purchase it. A question that arose in Foskett and McGowan was, what if the property has increased in value after the purchase? Can the beneficiary claim a proportionate share of the increased value? And this has been unclear in older cases, such as Rehallitz and Sinclair and Brougham, 1914. In these cases, it was suggested that the remedy was to reclaim either the property itself or place a charge over the property only to the value of the money actually taken. But in Foskett and McGowan, which was a House of Lords case, it was held by a 3-2 majority that yes, the beneficiaries are entitled to the proportionate share of any increase in value, which again is a key benefit to a proprietary remedy. I've set out the key facts of the case of Foskett and McGowan on the slide, but it's not important for you to remember these facts. It's the principle that is that holds good and is important. So, in the House of Lords case, it was held that the beneficiaries were entitled to a proportionate share of any increase in value, because remember, trustees cannot profit from their role as trustee. So, before Foskett, some commentators suggested that the beneficiaries should only have a proprietary claim for the return of the money that they contributed, although they would still have a personal claim against the trustee for the profit element, because the trustee was in breach of their fiduciary duty not to profit from the trust. But even where the increase in value may be attributable to the trustee's investment skills or work carried out by trustees, following Foskett and McGowan, the principle now holds good that the beneficiaries can place a charge which includes any proportionate increase in the value of the asset. So we're now moving on to the example of where there's a mixed fund, remember, a bank account where money obtained in breach from the trust has been paid in, and there already sits in the bank account money from the trustee's own personal funds. And this is looking at a more complicated situation, which is far more likely to occur in reality and also far more likely to be included in exam questions, where there's been a mixed fund and several withdrawals made from that mixed account. So what are we talking about here? Well, remember, tracing is referred to as following the property, either in its original or substitute form. So it's obviously important to know whose money in the bank account has been used to either purchase an asset or whose money has been squandered. And this is the case where the principles again were developed in Rehallitz. So where a trustee withdraws part of the mixed fund and squanders it or dissipates it, Rehallitz established that he's deemed to have spent his own money first. And the reasoning for that is that a trustee is entitled to squander his own money. So this means that it works in favour of the beneficiaries because they'll have a prior claim to the balance that's left in the mixed fund, and they can recover what belongs to the trust. So just to clarify, this is a situation where we're looking at a mixed account. So a trustee in breach of trust has paid some monies into a bank account that already contains some money from his own personal funds, so we've got a mixed account, it's important to decide if withdrawals are made. Some may be made to purchase an asset, some may be dissipated. It was assumed in the case of Re Hallett that the initial withdrawal was from the trustee's own funds, because in that case the initial funds were dissipated. So Re Hallett works satisfactorily as far as the beneficiaries are concerned, where the first withdrawals have been dissipated. It suits them to argue that the withdrawals were the trustee's own money and the money left in the account is theirs. But what happens if the trustee makes two withdrawals from the mixed account? And with the first withdrawal, he purchases an asset, but the second withdrawal is dissipated. And let's say, for example, that there's no balance left in the account. Obviously, the beneficiaries in this scenario would want to claim the asset, but they'd only succeed if it can be shown that the trust money was used to buy the asset, because equitable tracing follows the property. So, following Re Hallett, remember, the trustee is deemed to have spent his own money first. Now, this would mean that the trustee had bought the asset with his own money, and the trust money would have been dissipated or squandered. So, applying Re Hallett in this scenario would achieve an inequitable result. However, the situation that we've just considered arose in the case of Re Otway. In this case, the first withdrawal from a mixed fund was used to purchase shares, and then the trustee withdrew the remaining amount and dissipated the balance. If the rule from Re Hallett had been followed, remember, the trustee's first withdrawal is deemed to be his own money, then the trustee would have title to the shares and the beneficiaries would not be able to trace because their money had been dissipated, and this is obviously an inequitable outcome. It was stated by Justice Joyce in the case of Re Otway that the order of priority in which the various withdrawals and investments have been respectively made is wholly immaterial. So the principle arising from both cases, so Re Hallett is the leading case. Re Otway didn't undermine the rule, it simply established that from both cases everything is presumed against the wrongdoing trustee. So where there's a mixed fund and various withdrawals are made, where some may be used to purchase assets and some monies may be dissipated, as far as is possible, money that's dissipated will be attributed to the trustee's personal fund. Now, there are some criticism of this rule because although the rules in Re Hallett and Re Otway work to the advantage of the beneficiaries, they act to the detriment of the trustee's other creditors, and some would criticise the rules on this basis. So we've considered the rules in relation to equitable tracing. The key rules that we wish to follow are the prerequisites, which are set out in Re Diblock, and the rules in Re Hallett and Re Otway and Foskett and McGowan. You'll see from the sections in your textbook that there are several scenarios. There are scenarios where funds from two trust funds, for example, are mixed and they have a different set of rules. So we are concentrating on the situations that we've just covered. Now, let's have a look at common law tracing. Again, It's not of key importance to understand how common law tracing works. The main benefit of equitable tracing over common law tracing is that it allows beneficiaries to trace into trust property which has been mixed with other property. So we've seen that equitable tracing is only available to people who own equitable interests, where there's a fiduciary relationship. It's not open to owners of a legal interest unless they are owed a fiduciary duty. We also established that tracing is not a claim in itself, it's a mechanism for identifying the claimant's property in the defendant's hands to provide the basis for a claim. So, in comparing equitable tracing to common law tracing, equitable tracing can be used where there's an equitable proprietary interest, such as a beneficiary under a trust, or they are legal owners who are owed fiduciary duties, such as shareholders who are owed fiduciary duties by the company directors. Common law tracing is available to legal owners who are not owed fiduciary duties. One of the key advantages of equitable tracing is that it allows to trace into mixed funds. And as we said, property obtained in breach is often referred to as hot property. It changes hands, it's mixed with other property used to purchase assets, etc. So common law tracing prevents tracing into a mixed bank account or a mixed asset, and this is presumed to be because the common law cannot award a charge over the mixed fund or the mixed asset, because the charge is a creature of equity. Equitable tracing, as we've seen, has no difficulty identifying a claimant's interest in a mixed fund or asset. See Foskett and McGowan, for example, or Ree Hallett's estate. Another disadvantage in common law tracing is that you can only follow a physical asset. There is an exception in the form of cheques. The case of FC Jones and Sons was quite a controversial case, but it doesn't undermine the general rule that you cannot trace into a physical asset. So, for example, money that's been transferred electronically cannot be traced into. This is not the case with equitable tracing. So, now that we've concluded the key principles in relation to tracing, I suggest that in order to consolidate your knowledge and to help you prepare for the final workshop, you have a look at the additional exercise 2 that are included in the resources under this topic area. Additional exercise 2 gives you a brief scenario in relation to a breach of trust and mixing of accounts, and if you have a look at that in your own time and try to put together an answer, then I have also uploaded the points to note on this exercise, which will enable you to compare your answer and help you to prepare for the final workshop. And good luck. Hello, and welcome to the final podcast on breach liabilities and remedies. So today we're going to be concentrating on personal actions against third parties or strangers to the trust. So we're looking at third party liability. So why might you want to sue a third party? Well, as we've covered, when a breach has been committed and a loss to the trust fund and a link between the two, a beneficiary has the option, first of all, of suing the trustee, that's a personal claim, to make good any loss plus interest. Then they might have the choice of a proprietary claim, which was covered in the last lecture. A proprietary compensatory claim in the trust property, which may require tracing. And now we're going to look at the third option, which is to bring a personal action against a third party or a stranger to the trust. So a beneficiary under a trust may wish to bring a claim against a third party when the express trustee has maybe absconded or is bankrupt and there is no property to trace into. The property is not ascertainable in its either original form or its substitute. And so now we're going to look at in what circumstances can a beneficiary recover their loss by bringing an action against a third party. So first things first, we're looking at the liability of strangers. So let's just clarify what we mean by a stranger. So a stranger to the trust or a third party is any person who's not been expressly appointed as a trustee. So it can and often does involve someone that is involved with the trust, such as a solicitor, an agent, or even a beneficiary, but strictly speaking, anybody that is not an express trustee. So, in terms of the extent of the liability of strangers, it's not as wide as that of express trustees. So you remember from the first and second lectures, we keep referring to the wide liability of express trustees. So when we discussed this, we established that in general, the liability of express trustees exists independently of fraud, intent or personal incompetence. So you can be liable for a breach of trust if you act honestly and in good faith, but for example you don't have the requisite degree of knowledge or you're incompetent. This does not apply to third parties or strangers to the trust. Barnes and Addy is the authority for the principle that liability of strangers is limited. So strangers acting in good faith are not liable. Liability for third parties is fault-based. So for example, an agent acting in good faith will not be held liable. So liability of strangers exists in certain defined situations, and the situations that we're concerned with, or the circumstances rather, are dishonest assistance and knowing receipt. Knowing receipt being the more common type of third party liability. It's important to note at this stage as well that these are personal actions against third parties. So as with proprietary actions, you cannot bring an action against a third party who's a BFP, a bona fide purchaser for value without notice. So the defined situations as set out by Lord Selborne in Barnes and Addy are if third parties intermeddle, that's the wording used in the old cases, intermeddling. If a third party or a stranger to the trust intermeddles or participates in any fraudulent conduct of the trustee to the injury of the beneficiaries, equity fixes him or her with liability because of his or her unconscionable actions. Remember, equity acts on the conscience of the legal owner. So what are we dealing with then? Well, the first example you've got there is liability as a trustee desum tort. So remember back to your days of studying tort law. Tort is a civil wrong. So this means that you become a trustee of your own wrong. That's a general term. The Trustee Act 2000 defines trustee de son tort as a person unconnected with a trust who takes upon himself to act as a trustee. He's therefore liable as if he's been appointed as a trustee. So if you are not appointed as a trustee, but you become involved in the trust in such a way that you intend to be a trustee, and you breach the trust and there's a resultant loss, you will be held liable in the same way as an express trustee. The two types of liability, as I said, that we will be concentrating on are dishonest assistance and knowing receipt. And in all of these situations, the defendant becomes liable to account to the beneficiaries as though they had been trustees. They've rendered themselves liable by virtue of their participation in the breach of trust. This liability is construed by the court, hence the term constructive trustee. Remember, in all of these situations, the beneficiary have remedies against the trustee, a personal remedy to make good loss plus interest. They also have a proprietary remedy in the trust property if it's ascertainable in either its original or substitute form. So why might they decide to pursue the stranger instead? Well, as stated previously, the express trustee may be bankrupt, may not have enough money to meet the claim, and the property may be dissipated. Now, a third-party liability for receipt of property, knowing receipt, or as an accessory, dishonest assistance, is of real practical significance, especially as regards commercial and corporate fraud. So many of the cases are dealing with commercial and corporate dealings. But it also arises in the context of straightforward breaches of trust. And a point to note here is that the lack of clarity of the law in this area is a major weakness of third-party liability. It's generally understood that this area of law lacks clarity and therefore results in uncertainty, and there is criticism of the rules that have been developed, and we'll talk about those later on. As with most topic areas within equity and trusts, all roads lead to Lord Brown Wilkinson in West Deutsche, and in his leading judgment, Lord Brown Wilkinson stated that since the equitable jurisdiction to enforce trusts depends upon the conscience of the holder of the legal interest being affected, he cannot be a trustee of the property if and so long as he is ignorant of the facts alleged to affect his conscience. So equity acts on the conscience of the legal owner, and in order for the stranger or third party to have acted unconscionably, he or she must have had the requisite degree of knowledge that they were expected to behave in a particular way. So equity acts on the conscience. This area is fault-based, so some fraudulent or dishonest conduct. So in order for a constructive trust to be imposed on a third party, that party must have the requisite degree of knowledge of their participation in a breach of trust. And liability only occurs from the time at which the stranger knows of the breach. So, for example, if a third party receives trust property innocently, but then they become aware of the breach of trust at a later stage, they can only be fixed with liability from that point onwards, from the point at which they become aware of the breach of trust. So let's look again at a trustee desuntort, a trustee of your own wrong. You construed, hence the term constructive trustee, because of the way that you've become involved with the trust. So when a person has assumed the position of a trustee, in fact, even though he or she has not been properly appointed, but only where the person who has assumed the position of the trustee intends to act as a trustee. So this was recognised in Mara and Brown, where the defendant, who was a solicitor, advised the trustees of a marriage settlement to make certain speculative investments that caused a loss to the trust fund. The trustees argued that the defendant, solicitor, had intermeddled with the trust and was liable as a trustee desuntort. This was rejected because he neither intended nor purported to act as a trustee in providing the advice, rather he was simply acting as a solicitor. So it's clear from the dictum that is written out on the slide there that strangers who intermeddle in the business of a trust will be taken to have assumed a fiduciary duty to the beneficiaries of that trust. Indeed, they will be treated for all purposes of liability as if they had been expressly appointed to trusteeship of the trust. Of course, there would be no liability unless the stranger actually breaches the trust they have assumed and the breach results in a loss to the trust. The same causal link applies as to express trustees. So we're now looking at the first type of liability of strangers, and by far the most common, which is knowing receipt. You'll also see this referred to in textbooks and judgments as recipient liability. I prefer to stick to knowing receipt because it depends on you having received the trust property and having the requisite degree of knowledge. So we'll stay with knowing receipt. Now, the key case that set out the 3 requirements in order to fix liability under knowing receipt came from or were established in the case of Agip Africa Limited and Jackson, and they're set out there for you on the slide. So if you want to just read through those. So these are the 3 requirements. The first 2 are fairly straightforward in that it's got to be shown that you were in receipt of the trust property and that you benefited from receiving that property. The area which is controversial and which has raised criticism is the requisite degree of knowledge that you need to be fixed with liability. But before we go on to that, just to consolidate our understanding of this, we're going to have a look at a few sample scenarios. So we can see then that against third parties, you can either trace into the trust property a proprietary claim. So if the property is still ascertainable in either its original or substitute form, you could take out a tracing order and trace into the actual property itself, or you could fix the third party that was in possession of the trust property with constructive trusteeship, third party liability. So we're going to look at some examples and decide which would be most appropriate, a personal remedy or a proprietary remedy based on a different set of facts. So the basic scenario is we've got Diana as the trustee. She breaches the trust and she gives £50,000 of the trust money to her father, Keith. So in the first example here, Keith claims that he had no idea that the money did not belong to Diana. So remember, Diana is in breach of trust. She's transferred £50,000 to Keith, and it's important to remember that she transferred it without value. So Keith didn't give any value for the £50,000. So here, as long as Keith is still in possession of the £50,000, a proprietary claim would be easier to establish. Keith is a volunteer, so he didn't have any idea, or claims not to have any idea, that the money was obtained in breach. So he's a volunteer, and remember, you can trace into property into the hands of third parties against anyone other than a BFP, a bona fide purchaser for value without notice. So Keith may well be what we refer to as an innocent volunteer, but he hasn't given good value for the trust property, and so he's not protected, and the beneficiaries can trace into his hands and recover the trust property if it's still ascertainable. The second example, after learning that the money belonged to the trust, Keith dissipated it. In this situation, a proprietary claim cannot be brought, because if the defendant no longer holds the property, nor its replacement, there's nothing to trace into. Remember, the tracing rules establish that there must be some ascertainable property, either original trust property or its substitute. If property is dissipated, there's nothing to fix a proprietary claim onto. It states on the second example that Keith had learned that the money belonged to the trust. So at this point, he did have the requisite degree of knowledge, and so he can be fixed with personal liability. So the beneficiaries could bring a personal claim against Keith to make good the loss plus interest. The third example, Keith has now been declared bankrupt, would mean that it wouldn't be advisable to make a personal claim against Keith, because a personal claim ranks alongside other personal claims and you wouldn't recover the full loss. So if Keith is still in possession of the £50,000, again, a claim under a constructive trusteeship, a proprietary claim would be advisable. So just to clarify, in all of these situations, although that we're simply looking at whether we'd advise in terms of claiming against the third party, and here that's Keith, the beneficiaries always have the initial remedy of claiming against the express trustee, who in this case is Diana. So if Diana can make good the loss plus interest, the beneficiaries could choose to sue Diana in a personal claim. So in the case of Eagle Trust and SBC, it was stated that if a stranger receives trust property but doesn't find out about the breach until some later date, he or she will not be liable as a constructive trustee until and from the date the stranger has the relevant knowledge. The question is, what is the degree of knowledge that must be shown? And there's considerable debate over the level of knowledge required for liability. The starting point is the Baden case. So in the Baden case, the 5 classifications referred to as the Baden classifications of fault were set out. So the most controversial question relating to third-party liability is whether the third party's liability should be strict or fault-based, and if fault-based, what degree of fault is required to establish liability. So the starting point for the requisite degree of knowledge in relation to knowing receipt and dishonest assistance is the Baden case. So you can see there are 5 degrees of knowledge, ranging from actual knowledge or express knowledge through to what could be considered as incompetence or negligence. So knowledge of circumstances which would put an honest and reasonable man on inquiry, but didn't put that particular person on inquiry. So ranging from actual knowledge, and the remaining 4 is situations in which the court can impute knowledge. So examples of constructive knowledge. The first 3 types of knowledge, and this again comes from the old case law, are sometimes referred to as naughty knowledge, or involving not perhaps dishonesty but a lack of probity, so turning a blind eye, etc. The final 2 heads, as we say, range through to negligence, so not knowing that an ordinary reasonable person would be put on inquiry. Now, until the Montague case, it was thought that any of the 5 Baden heads would suffice to establish liability under knowing receipt. So the defendant was liable if he received trust property not actually or expressly knowing it to be such, but in circumstances that a reasonable man would have known. So no element of dishonesty was necessary. Re Montague is authority that only the first 3 types of Baden knowledge would suffice for the purpose of fixing liability as a constructive trustee for knowing receipt. And this was endorsed in Westdeutscher. So there must be an element of dishonesty, perhaps not dishonesty, but a want of probity in the defendant's behaviour. Constructive knowledge is not enough. McGarry argued that otherwise this could lead to harsh consequences, especially if the recipient had dissipated the property, as then if they were held liable, they would have to pay compensation out of their own funds. Now, the problem with the Baden categories, and they have been criticised, is that they don't really provide a workable test. How easy is it for a person to fit a person's state of mind into the Baden categories? So would it be easy, for example, to distinguish willful and reckless failure to make inquiries from an honest but negligent failure to make inquiries? So the categories are by no means watertight, and one can easily envisage cases that sit on the borderline of these categories. So I've set out some of the key facts of the Re Montague settlement trust case there, but the facts are really not important. It's the principle that came from this. And this shows that we have a series of cases in which the test for the requisite degree of knowledge is uncertain. It changes from case to case. So although in Re Montague settlement trust, the breach of trust did lead to a proprietary claim, so it was possible to claim some of the actual property back because it was traceable in an ascertainable form. The 10th Duke was not held personally liable as a constructive trustee because he didn't have the requisite degree of knowledge to fix personal liability. And in Re Montague's, it stated that the requisite degree of knowledge was set out as under the first 3 heads only from the Baden categories. In the Age of Africa case itself, which was basically a money laundering operation, Millett went further than Re Montague and stated that liability required clear evidence of dishonesty. But the cases are not clear on the requirement of dishonesty. Montague would suggest that merely knowledge, i.e. the first 3 heads, is sufficient, whereas Age of Africa is stating that there must be clear evidence of dishonesty. The true distinction is between honesty and dishonesty, and not between various levels of knowledge. So we've seen that the Age of Africa case established that dishonesty was the true test. There had to be clear evidence of dishonesty. But again, we have a case which suggests here, the El Ajou case, that constructive notice may be sufficient. And a quotation taken from the judgment of Millet in El Ajou again is often criticised as showing favour to commerce and business. A recipient is not expected to be unduly suspicious. So when looking at commercial relationships, what would be considered to be standard practice within the business environment will not necessarily fix liability on a third party. The final case, which looked at the test for the requisite degree of knowledge under knowing receipt, is BCCI Limited and Aken Deal. And the Court of Appeal decided in BCCI that dishonesty was not an essential ingredient for knowing receipt. So this is the most recent decision on the question of knowledge. The Baden categories were said to give rise to difficulties of definition and allocation, and a broader test was applied, which asks whether the defendant's knowledge would make it unconscionable for him or her to retain the property. So in BCCI and Aken Deal, the Court of Appeal decided that dishonesty was not an essential ingredient, and it appears likely then that constructive notice could be sufficient to make it unconscionable for the defendant to retain or deal with the property, and would therefore suffice to fix liability. So this is the most recent test. Would it be unconscionable for the stranger to retain the property? But it has been heavily criticised. In the Aken Deal case, a number of employees of a company breached their fiduciary duties by procuring the company to enter into an artificial investment agreement with the defendant. The claimants, who were the company's liquidators, sued the defendant for knowing receipt. But the defendant was unaware of any facts that questioned propriety in the loan transaction, even though it involved a very high interest rate. And it was stated that in a commercial case, the court will assess whether a reasonable person would have made inquiries in the light of common business practice. So dishonesty will lead to liability, but it's not an essential requirement. A state of mind less culpable than dishonesty, such as constructive notice, an example of this would be turning a blind eye, will suffice. The problem with this definition of the test is that it gives no guidance as to what constitutes unconscionable conduct. And the question is really, what is the difference between unconscionable conduct and dishonest conduct? So there is a lack of certainty in the test, and we know that the law doesn't like certainty, so the current state of the law has been criticised. The second type of third-party liability that we're going to look at is dishonest assistance. You may see this referred to as procurement of a breach of trust, but again I prefer to stick to dishonest assistance because it relies on some assistance in a breach of trust, and evidence of dishonesty. So if you're looking at a problem scenario and you see that a third party has become involved, intermeddled in a breach of trust, you would either apply the rules in relation to knowing receipt or dishonest assistance. And quite simply, the way that you would determine which was the correct application is look at whether the stranger has actually come into possession of the property, and this is far more common. So if the third party or stranger has come into possession of the property, then you would apply the rules in terms of knowing receipt. If they've assisted in a breach, such as an accountant paying over money by a cheque, they haven't actually come into possession themselves, but they've assisted in some way, then you would apply the principles in terms of dishonest assistance. So it's not based on wrongful receipt of trust property, it's fault-based. A person never actually receives or handles the trust property, but assists in some way in a breach of trust. So let's look then at the requirements to fix liability under dishonest assistance. And these were set out in the TAN case, Royal Brunei Airlines and TAN, which is the leading case on dishonest assistance. And there are 4 requirements. The first one, the existence of a trust or a fiduciary relationship. So a fiduciary relationship is sufficient. So where a director of a company, for example, misappropriates company-owned property by passing it to a third party, say by the medium of the director's private bank account, the director could be liable for dishonest assistance. A breach of trust or fiduciary duty. So there's got to be a breach of trust or fiduciary duty. Now, according to Royal Brunei and TAN, the breach need not be dishonest or fraudulent. A stranger can be liable if he participates or instigates a breach of trust committed by an honest trustee. The assistance by the stranger in that breach, so the stranger or third party assists in the breach of trust, and then the stranger must have been dishonest. So remember that liability is not as wide as for express trustees. So in terms of third party liability, negligence is insufficient for liability. And since the Royal Brunei Airlines case, it's clear that the original design of the trustees need not have been dishonest and fraudulent in order for the stranger to be liable as an accessory. On the contrary, the principal breach might have been quite innocently performed. The focus is now upon the accessory's state of mind. Whereas previously, prior to the TAN case, strangers would only have been liable if they had known of the trustee's dishonesty. So, for example, if a dishonest solicitor were to persuade an honest trustee to apply money in breach of trust, the solicitor could be held liable to compensate the beneficiaries for loss arising from the breach, even though the trustee honestly believed that he or she was acting properly. So the trustee would still be personally liable, but if they were insolvent or if they were protected by an exemption clause or they were relieved from liability framed in one of the defences that we looked at in the first lecture, then you'd be advised to bring an action against the third party. So when we looked at the requirements to fix somebody with liability under knowing receipt, we said that there was criticism over the lack of certainty as regards to the test for the requisite degree of knowledge. With dishonest assistance, the problem lies, and there's certainly criticism, in the way that dishonesty has been defined. So in the case of Royal Brunei Airlines and TAN, Lord Nichols gave the leading judgment, which represented the majority, and this was a Privy Council case, and it established an objective test. So dishonesty means not acting as an honest person would in the circumstances. So a person who knowingly misapplies another's property can't escape liability by pleading that applying his moral code, i.e. subjectively, he saw nothing wrong in his behaviour. So, for example, if the defendant is a solicitor, the court will ask, would a reasonable solicitor, knowing what this defendant knows and with this defendant's experience, have acted as the defendant did? So it's an objective standard of honesty. And that is, for professionals, is a higher standard. And in the Tan case, following the objective test, the defendant was held liable. Unfortunately, however, in the House of Lords case, Twinsectra and Yardley, the House of Lords subjected the comments of Lord Nichols to careful scrutiny, and they approved the decision in Royal Brunei and Tan, then went on to explain the test for dishonesty, but it's argued that they misinterpreted the test that was set out in the Tan case. So the House of Lords held that a defendant is dishonest if his conduct is dishonest by ordinary standards of reasonable and honest people, and he realises that by those standards his conduct is dishonest. So in the Twinsectra case, Lord Hutton, who gave the leading judgment for the majority, identified 3 different tests for dishonesty. First, a purely subjective test. Second, a purely objective test. And the third possible test is a hybrid test. And the hybrid test is the test that's applied in criminal law in relation to the crimes of theft and fraud. And it was held in Twinsectra that the Tan case is intended to apply the third test, the hybrid test. So, in misinterpreting the test that was developed in the Tan case, the House of Lords case of Twinsectra essentially created a subjective test. So first of all, you ask, was the defendant's conduct dishonest by the ordinary standards of reasonable and honest people, an objective test? But by adding the second question, that he himself realised that by those standards his conduct was dishonest, it's essentially making the test subjective. And a criticism of this is it allows defendants to escape liability in a much wider set of circumstances, and the defendant was held not to be liable in Twinsectra. So, criticism is that the test will allow too many defendants to escape liability because they can argue that they thought that their behaviour was common practice in the commercial world and they would not be labelled dishonest by others in the same profession. Now, this interpretation, it's generally understood, was incorrect. The hybrid test was not recognised in the Tan case, which was a Privy Council decision. In fact, the Tan case specifically rejected the criminal test. Tan applied the objective test, and it was this objective test that was recognised by Millett in his dissenting judgment in the Twinsectra case. But we have a situation now where we have a Privy Council decision that's created an objective test and a House of Lords decision that's created a subjective test. In the more recent Privy Council decision, Barlow Clowes International Limited and Eurotrusts International Limited, this case dealt with the test for dishonesty in cases of knowing assistance, and the Privy Council argued that the second element of the so-called twin sector test had been misconstrued, that there was no need to show that the defendant knew that he was acting contrary to the standards of honest people. Dishonesty meant that the defendant's conduct is dishonest by ordinary standards of reasonable and honest people. So it took us back to the objective test, which was set out by Lord Nichols in the Tan case. Lord Hoffman in Barlow Clowes said that Lord Hutton and the majority in Twin Sectra had not intended to adopt the hybrid test, but they had been simply seeking to explain the test, and this was confirmed and approved by the Court of Appeal decision in Abu Rama. So the Abu Rama case is quite unusual because we now prior to the Abu Rama case, we had a situation where we appeared to have ambiguity between a Privy Council formulation and a House of Lords formulation as to what constituted dishonesty. So this is an unusual situation, and Lady Justice Arden in Abu Raban said that this was one of the exceptional cases where the High Court or the Court of Appeal can follow a Privy Council decision and not a House of Lords decision, because all of the judges that sat in the Privy Council case were also members of the House of Lords, and a number of the judges in both the Privy Council and the House of Lords decision dealing with the same legal issue were the same judges. So Abu Ramu, the Court of Appeal case, followed the Privy Council's interpretation, and we are now back to the objective test. And arguably, this is much more acceptable on policy grounds because it allows doesn't allow defendants to escape liability by adding the subjective element.